Morning. So you specialise
Yes.
in helping people in these situations.
Absolutely.
Just Karen actually has got in touch with us this morning. Asked the question everyone's going to be thinking straight away: how can someone still be on the roads with 62 points? It shows total disregard for the law. There are no circumstances, she says, that should allow this sort of thing to happen. It beggars belief. 62 points and still on the road.
Yeah, I was scratching my head myself how that could have happened, but a court has heard that person's circumstances and we don't know what they are. And that's the very point. Every court has to consider each individual case on its own facts.
And every time you present to the court, bear in mind 12 is the point at which you lose your licence.
Yeah.
We're talking about 62, but you've represented people with 30 points on the licence. Every time you have to present a different reason. Is that correct?
You can't present exceptional hardship twice on the same facts within a certain period of time.
So the first time I come to court, I say, you know, my mum needs a lift to hospital every Tuesday, but I can't use that again the next time I have more points.
Yeah, I think you'd have to say something a little bit more than that, and ultimately the court has to be satisfied based on evidence. It's not just a bit of a sob story. You can't walk in and say something like that example. There has to be exceptional hardship, and the court will consider whether or not people connected to the offender are likely to be caused hardship. They have to place greater weight on people such as a relative that might need assistance, although visits to hospital once a week is not going to cut it. But they would have to consider whether the hardship would be caused to others, such as an employer or their children, or it can be all manner of things, a doctor and their patients. It could be anything, as long as the court's satisfied it's exceptional hardship. But yes, you couldn't present the same argument twice.
Do you understand Brake's call for 12 points means that's it, there's nothing, there's no appeal? I know it's in your interest to defend these people, but
Well, we're not defending when we're presenting exceptional hardship, we're presenting mitigation, which is different. The person that walks into court and accepts that they've done wrong, but they ask the court to consider what the ramifications of a 6-month ban, which is the starting point for totting up, would be. I think there does need to be, we need to maintain the court's ability to depart from that penalty. I think it can be harsh in some circumstances. For example, somebody's direct debit lapses and they find themselves with no insurance. There's no defence. You can't say, I didn't realise, and that will get you out of that. So that's 6 to 8 penalty points. And if that happens a couple of times, then that person very quickly reaches 12 points. It's nothing to do with their driving skill. It can be an administrative oversight. Is it fair that that person then loses their job? I'm not sure it is.